Another power that Congress has is the power to make all laws which are necessary and proper to carry into effect the other laws which Congress is allowed to enact. The victory on this one for the pro-Constitution side, for the people who believe in constitutional federalism, that is, the people who believe that it's very important that the Articles of Confederation were replaced by a Constitution that created a strong national government to do the many things which we need a strong national government to do to preserve liberty, starting with national defense and many other things as well. But the grant to Congress of those enumerated powers in the Constitution grants Congress the power. Congress should be able to fully and powerfully exercise those powers, but that doesn't mean that Congress can do everything. It means Congress is granted the power by the people to do a limited number of things and to do them well, but not to act on everything. The necessary and proper clause, as Chief Justice Roberts in his opinion explains it, is very much in line with how the necessary and proper clause was originally understood at the time of the framing of the Constitution, and how it was expounded in probably the most important case in constitutional law ever, the 1819 unanimous decision in McCulloch versus Maryland by Chief Justice Marshall. And Chief Justice Roberts, all of the congressional Supreme Court statements about the necessary and proper clause have gone all over the map over the various years. Chief Justice Roberts brings it all home to the original meaning. And he explains, first of all, the necessary and proper clause doesn't grant Congress any new powers. All it does is express something which is generally implicit, but for everybody's understanding, the drafters of the Constitution decided to make it explicit, which is when you grant somebody a principal power, unless you say something to the contrary, you grant them the incidental powers that go with it. So let's say I'm going off to go live in St. Petersburg for 2 years, and I want somebody to take care of my house and say, Ari, I'm going to pay you $3,000, and I hereby grant you the power to manage my house for the next 2 years. Now, that's Ari's principal power, the power to manage the house. Did I say he could paint the fence? Did I say he could pay the property taxes? Did I say he could hire somebody to cut the lawn? I didn't say any of those things. But those things, like hiring the lawnmower or getting the fence painted, are incidents of the principal power to manage the house. And so when I said manage the house, I didn't have to say every little thing that goes with it. That's what the necessary and proper clause says, is when Congress has granted these other powers to raise and support our armies, to regulate commerce among the several states, to establish a uniform law of bankruptcies, or for patents, that when these great powers are listed, that all the incidental powers that would be typically associated with them go with those powers as well, and Congress can do that. Now back to my house. Let's suppose 3 months after I've left, some developer comes along and says, I really want this house because I want to tear it down and I want to build the finest strip club in Boulder, and this is the place I want to do it. And I will pay you twice the assessed value of this house. Well, Nari's thinking to himself, wow, that is a great deal. You know, I know Dave likes his house, but he gets to sell it for twice what it's worth. Did he grant me the power to enter into a contract to sell the house? And the answer is no, because I granted him the power to manage the house. And with that came these incidents like taking care of the lawn and the fence and the plumbing and all that. But the power to sell a house is equally great as the power to manage the house. Maybe it's even a greater power. I didn't grant that one. So the fact, if I'd said, all right, I grant you the power to manage the house and whatever is necessary and proper to manage the house, but read it like the U.S. Constitution. Even with that, Ari doesn't have the legal authority to sell the house, because the power to sell the house is not an incidental power of management. It is a power that is equally great as the power of management. And so what Chief Justice Roberts explains, and this is very much based on the Independence Institute amicus brief we filed, based on the research by my Independence Institute senior fellow Rob Nagelson, retired law professor from the University of Montana, who is co-author, excuse me, co-author of the book called the Origins of the Necessary and Proper Clause, which goes back to contract law and all kinds of laws at the time of the founding, and shows how the necessary and proper was a very common legal term of art along the lines I've just explained it to you. So it wasn't something that was at all opaque or mysterious. It had a very well-defined meaning. So Chief Justice Roberts explains anything that comes out of the necessary and proper clause must, by definition, be something that is an incidental power of one of Congress's other enumerated powers. There's nothing freestanding in the necessary and proper clause. Everything in there has to be an incident of an enumerated power. And so this power that the Department of Justice, President Obama, and Nancy Pelosi assert, the power to compel someone to engage in commerce. That, Chief Justice Roberts says, that's not an incident of the power to regulate interstate commerce. The power to compel commerce, to force an unwilling person to engage in commerce, is no incident of the power to regulate interstate commerce. Rather, it is a power that is equally as great as, maybe even greater than the power to regulate voluntary commerce. And so therefore it can't possibly be something that's in the necessary and proper clause. And Chief Justice Roberts, following Chief Justice John Marshall in McCulloch versus Maryland, applies his analysis, which is the clause is not the necessary clause, it's the necessary and proper clause. So for a law to be necessary and proper, it has to be first necessary and it has to be proper. Those are two distinct inquiries. In McCulloch versus Maryland, Chief Justice Marshall explained necessary as not meaning absolutely necessary. It's the only way you can get things done. Some people that are like Thomas Jefferson are argued for that meaning, but Chief Justice Marshall rejected that, and among the reasons I think he was correct was elsewhere in the Constitution, they knew how to say absolutely necessary. States cannot, under Article 1, Section 9, states may not impose taxes on imports or exports from the states, except when absolutely necessary to enforce the inspection laws of those states. And Chief Justice Marshall pointed out, they didn't say absolutely necessary. They said they knew how to say absolutely necessary on the state import-export tax section. They didn't say absolutely necessary in the necessary and proper clause. So according to Chief Justice Marshall and Chief Justice Roberts, necessary just means appropriate or convenient. It's one way of going about things. And yes, is the individual mandate necessary in that broad sense of the term? Yes, because when you force insurance companies to issue policies to anyone who applies, and you prohibit rating insurance companies from pricing the policy based on the person's health risks, then the insurance companies will be out of business very quickly, unless you can force other people who have very low actuarial health risks to buy enormously overpriced insurance in order to subsidize the people who we just were forcing the insurance companies to do business with in the other part of the law. So yes, it is necessary in that sense, but Chief Justice Roberts explains it's not proper because it's not an incident. It's not an incidental power of the power to regulate interstate commerce.